Testing, can you hear me?
Mr. Maxwell, are you able to unmute? We're not able to hear you. It looks like on your screen it says it's muted.
Just send me an email. Okay, I got your email. Okay.
Ms. McWilliams, could you please say something over WebEx to make sure we can hear you in the courtroom?
Can you hear me now?
Yes,
I can hear you. Can you hear me?
Yes, Mr. Maxwell, we're able to hear you. Thank you.
Excellent.
Let's come back from the break, please. We have finished commissioner questions, so now we'll turn to party questions of Dr. Tischler. Mr. Maxwell, do you have questions of Dr. Tischler? You have to unmute yourself. Okay, thank you. I can see that your statement in the chat that you have no questions. Thank you. And I'm sorry we have developed a couple of technical difficulties in this hour. Let's see, Ms. Taylor, do you have questions? All right. Mr. Cox.
I have no questions.
Thank you. Mr. Hightower, whom I don't see in the room. Mr. Davis. All right. Ms. Nasi or Mr. Dodd?
Madam Hearing Officer, I wanted to address one thing before I get started with my questioning. In containing or not containing any exhibits and then containing exhibits as of this morning. And I wanted to see if we could get a ruling on whether 13 is coming in with the exhibits or without the exhibits, because I just don't know what I'm supposed to cross on.
Yeah, thank you for raising that. I should have brought it up earlier. When we were going over the testimony last night, obviously his testimony talks about his exhibits, LTD, LTC, LTD. we looked at the website and it did not contain those exhibits. So this morning we filed a corrected version that did contain those exhibits. Our preference is to offer it with the corrected version because that's obvious in his testimony. We didn't get any inquiries from any of the parties about that. And certainly that's our preference.
Mr. Dodd, did you have an objection to the corrected Exhibit 13?
I do have an objection, just because I haven't had these materials until today. While I see that there are a couple of references to them in the testimony, I was unaware of the exhibits, and I think it's almost 100 pages worth of materials that I hadn't seen until about 11 o'clock today. And so that would be my objection, is that I haven't had an opportunity to review them and adequately prepare to cross-examine on them.
Okay, Ms. Fox, we need you at a microphone.
Your desk and one over there on Mr. Wessler's table. Get it for him.
Hello. Amigos Bravos and Sierra Club joined the objection. There's obvious prejudice from not seeing these highly technical exhibits until this morning or just a little bit ago. I think it's prejudice obvious. And so the omission is inadvertent, on their part on the one hand, but the prejudice is great on ours. They did attach to their filing on May 6th, which was the filing date, May 6th, Mr. Tischler's resume, so that can be entered into evidence. We have no objection to that.
Right, Mr. Wexler.
Yeah, I mean, first, there's not 100 pages, but those things are very clearly called out in his testimony. He discusses each of the exhibits at some length and why they're important. It's just, there was a technical issue with our paralegal. It's surprising to me now that there's this kind of prejudice when obviously nobody looked at the testimony before the filed version, because the version that we have at our office obviously has the exhibits. I mean, it's also a little surprising to hear about prejudice from parties that are putting in exhibits like, left and right almost on a daily basis. So I don't see the prejudice given that he's already discussed the importance of each of those things. The commission should have the ability to refer to those so that they understand the basis for his opinions.
Mr. Davis.
Madam Hearing Officer, guardians would object on the same grounds that were explained by Mrs. Fox. I just want to note that.
Okay. At this point, I'd like to accept them at least as part of an offer of proof. I'd like you to cross-examine to the extent you can cross-examine on them. And I'll take another look when I have a chance to look at them.
Thank you, Madam Hearing Officer.
Go ahead. I'm sorry, Pam, before you start, Pam was drawing my attention to the chat and going to use my phone. Oh, okay, I see. Mr. Maxwell also joined in the objection. So let me ask, Mr. Maxwell, are you able to hear what's happening in the hearing room again? Okay, he just confirmed that he can hear. So I believe our technical issues, with the exception of Mr. Maxwell perhaps being unable to unmute himself, I believe our technical issues are resolved for the moment and we can continue. Okay, go ahead, Mr. Brown.
Thank you very much. It's Dr. Tischler, is that correct?
Yes.
Dr. Tischler, I want to start with one of the main points that you make in your testimony. You state that there is no regulatory justification to prohibit discharges of produced water, correct?
Yes,
Now, I want to be clear because with a couple of exceptions, the EPA has set forth a prohibition on the discharge of produced water, haven't they?
yes, it's a federal rule in certain parts of the country.
And that's 40 CFR section 435.32. Is that right?
I'd have to look at the rule, but that sounds correct.
If I read it to you, might it ring some bells?
Well, I know what it is. The site that you refer to, I don't, as 435.2, if I recall correctly, it deals with the discharge of produced waters to public owned treatment works.
Okay, so let me read 435.32, okay?
Yes,
Except as provided in sections 125.30 through 125.32, any existing point source subject to this subpart shall achieve the following effluent limitations representing the degree of effluent reduction attainable by the application of the best practicable control technology currently available, parens BPT, colon. There shall be no discharge of wastewater pollutants into navigable waters from any source associated with production, field exploration, drilling, well completion, or well treatment, parens, i.e. produced water, drilling muds, drill cuttings, and produced sand, close parens. Does that ring a bell?
yes, that's correct.
Okay. And so these mics are truly terrible. And so the EPA has determined that there are regulatory justifications to prohibit the discharge of produced water, hasn't it?
In certain areas of the United States, correct.
Right, now I want to shift and I want to talk about the Big Spring water system, okay?
Yes,
The Big Spring direct potable reuse of municipal wastewater system is run by the Colorado River Municipal Water District, or the CRMWD, correct?
yes.
So through that system, the CRMWD processes municipal wastewater, including human excrement, and sends the produced wastewater, or sorry, the processed wastewater out as drinking water, correct?
As I mentioned, I'm not sure where we're getting the feedback. That is my understanding, although as I understood it, and again, I'm not personally associated with that facility, they actually put it through a storage pond.
Okay. But ultimately, that processed wastewater goes out as drinking water, correct?
I wouldn't call it processed wastewater, the municipal wastewater, yes.
Okay. I mean, presumably they do
Domestic
process it and treat it.
It's the treated processed wastewater.
Okay. Now, I'd like to pull up a portion of the CRM WD website and ask you a question about it, okay?
Okay.
And Ms. Jones, did you receive my email with that link? Thank you very much. Perfect. And Ms. Jones, if you could please scroll down to where we can see the text below. Yes. Nice and small. let me read a small portion of that, okay? And just for the record, we're looking at the Colorado River Municipal Water District website, specifically their tab on water quality. This portion of the website states, quote, oil and gas development began in the 1920s when little was known of environmental best practices. Brackish water would come in contact with freshwater supplies, and abandoned wells were often left unplugged or improperly finished, allowing the salt water to seep into local surface and groundwater supplies. As a result of this, salt contamination, West Texas's usable water resources have been severely limited. Do you see that there?
Yes,
And so the oil and gas industry is responsible for the contamination of Big Spring's water sources. Isn't that right?
this is what CRWMD posted. I'd actually have to look at Texas's 303D reports to see if it's all attributable to that or how much of it is natural
Okay.
salt water, because in fact, many West Texas streams have naturally high TDS. In other words, I'm saying that's their statement. But
Okay.
I can't verify that it's 100% accurate. It probably has some accuracy, but I can't verify it.
Okay. Do you think at least to some extent that's true?
I think it's possible. I don't say it's true.
Okay. And so perhaps because of the oil and gas industry's contamination of water supplies in West Texas, Big Springs now has to reuse municipal wastewater containing human excrement as drinking water. Is that right?
No, that's your tech. Again, as I stated before, I see a statement. I know that there have been historic in Texas problems with abandoned wells draining salt water into streams, but I don't know that's a fact for this particular discharge, for this particular location stream. You would have to look in the Texas 303D listing report to see if in fact the stream was listed because of the presence of salt water from, in this particular example, oil field development.
Do you have any reason to doubt the CRMWD statement here?
I just don't know. I'm not gonna, I can't answer what I don't not looked at. I could find out, but the answer would be that's their position, and there may be truth to it. It may be completely accurate. It may be partially accurate.
Okay. All right, I want to shift gears now, and I'd like to talk about your past work, okay? You would agree that you work predominantly for corporations and industry, correct?
Yes.
Your CV states that your clients include the American Petroleum Institute, the American Chemistry Council, the Pharmaceutical Research and Manufacturers of America, Western States Petroleum Association, National Mining Association, and numerous private companies, correct?
Yes.
One of the private companies that you've done extensive work for is ExxonMobil.
Yes.
You, for example, have commented, spoken, or testified on behalf of Exxon before the EPA, the California Regional Water Quality Control Board, Illinois Pollution Control Board, the Montana Department of Environmental Quality, and many other regulatory agencies.
Yes.
Would you agree that you have been paid millions of dollars throughout your career from your work testifying and advocating on behalf of oil and gas groups, associations, and companies?
I wish.
How long have you been doing this work?
It would have started, the work started when I worked for engineering science. So that part of my career started in 1973. So it would be 51 years.
Okay. And in this case, you're providing testimony on behalf of the New Mexico Oil and Gas Association.
Correct.
And You have been and continue to be paid for your work for Namoga, is that right?
Correct,
How much does Namoga pay you per hour?
$230.
And how much has Namoga paid you to date for your work in this case?
I'm not sure we've billed them yet.
Do you have a running tally of how much you intend to bill them for, how much you have booked thus far?
I billed straightly on hours actually worked and expenses. My partner handles the accounting. And so I honestly don't know. If I had to give a rough estimate, probably $10,000.
Okay. Now I want to talk about some of your work for the American Petroleum Institute, okay?
Yes,
In 2019, you helped draft comments in response to the EPA's Preliminary Effluent Guidelines Program, Plan 14, on behalf of the American Petroleum Institute, correct?
correct.
And I have here a copy of those comments along with their cover letter. And I'd like you to take a look at these as I want to ask you some questions about them, okay?
Okay.
May I approach the witness? These are those comments that you helped draft, correct?
Yes.
Now, if you could please turn to page 7.
Yes.
If you look there at the highlighted section, one of the comments was to request that the EPA, quote, consider the benefit of more neutral nomenclature in managing public perceptions, open parens, e.g. produced water instead of wastewater and treated produced water when discussing discharge scenarios, close quote. Did I read that correctly?
Yes.
And so one of the things that you and the American Petroleum Institute wanted the EPA to do was to change their terminology in order to manage public perceptions, correct?
Yes.
Because it's more beneficial for the American Petroleum Institute if we give produced water a innocuous name like produced water rather than fracking waste, for example.
The answer would be because produced water is different from industrial wastewater. I was trying to suggest that we use the term produced water primarily so that it recognizes the difference between that and from an industrial manufacturing process such as petroleum refining.
Okay. And so you wanted to do that to manage public perceptions?
Yes, so it could be viewed as different material and different from a different kind of source, not from manufacturing.
So it didn't have to do with the fact that this was in fact wastewater.
Well, let me just describe what I was describing earlier. Yes, it certainly could be called wastewater, but wastewater is also water that can be reused and recycled, right? Doesn't matter. As I described to the commissioners earlier, we know how to treat almost any type of water to ultimately a use that we find acceptable, whether it's a potable use or whether it's a reuse for industrial process. It's a matter of cost and the technology available.
Okay. And so your testimony is that you were recommending that they not refer to this stuff as wastewater and instead refer to it as produced water so that you'd be more accurate? Is that?
Yeah, because it's closer to what the terminologies that we generally use, produced water, is not really the same as what we would call industrial wastewater or municipal wastewater. That's the terminology that historically has been used in environmental engineering.
But the public doesn't have that level of technical expertise to be able to understand exactly what these different things are, right?
Well, that's correct.
And so really the API wanted to change the terminology and the way that we're referring to this stuff is so that the terminology wouldn't include that this was a waste, right?
You know, I suppose, I'd be perfectly honest with you, I wrote this, but you know, it speaks for itself. Like
Okay.
enough.
Okay. And so ultimately, the reason for that suggested change was to, quote, manage public perceptions.
Yes,
Correct.
it states that.
Thank you. Can I retrieve the document? Thank you. Now, I want to talk to you about ELGs just briefly, okay?
Yes,
ELGs are effluent limitation guidelines.
correct.
The EPA has not developed specific ELGs for produced water because the EPA simply says no discharge of pollutants, correct?
No, you didn't read the entire part 435. In fact, produced water can be discharged west of the 95th parallel.
Right.
And there are effluent guidelines for those.
Under the exceptions, correct?
It's not an exception, it's a set part of the rule.
Okay. So outside of the west of the 98th meridian, there are no standards, correct?
If I recall correctly, what and we can look at 435, it basically says the standards can be set on a site-specific basis, as I recall. And if I recall correctly, there actually is an oil and grease standard for stripper wells, which is one of the subparts.
Okay. Stripper wells are treated differently.
Yes, they're a subcategory within the category of oil and gas extraction.
Okay. Now, let's talk about produced water research, okay? To date, you have only ever authored one concerning produced water, correct?
And I don't even recall what paper I authored with respect to produced water.
That paper was titled, quote, "An evaluation of protective concentrations for hydrogen sulfide in produced water discharged in California outer continental shelf ocean waters," correct?
Yes, I was a co-author of that paper. I was not the primary author.
You weren't the principal author.
That's correct.
Andrew Glickman was the principal author.
That's correct.
And that paper was presented at the 1999 SPE EPA Exploration and Production Environmental Conference of the Society of Petroleum Engineers, right?
I don't have the document in front of me, but
Sounds about right.
It sounds accurate.
Now, that paper looked simply at the level of hydrogen sulfide released into the ocean through the discharge of produced water at 3 offshore oil platforms and whether the levels would be toxic to marine life, correct?
Yes,
That paper did not involve the analysis of any constituents of produced water other than hydrogen sulfide.
not that I recall.
And now that I've reminded you of it, that's the only paper that you've been an author of regarding produced water.
That's correct.
And you haven't ever received any grant money for research into produced water, have you?
No.
And so you would agree that your body of research concerning produced water is quite limited.
Yes, I agree. It's not been my primary focus.
Now, you are aware of the research of Dr. Avner Vengosh, correct?
Only to the extent that it's been discussed in this hearing.
So you're not aware that Dr. Vengosh is one of the most highly cited researchers in the world?
I have no comment.
Do you know what an H-index score is?
No,
So you're not aware that an H-index score is a measure of an individual's research performance?
no, I'm not, because as you're well aware, I'm not an academic.
You don't routinely stay up on the research regarding produced water?
As I've testified to in this hearing, that testimony has not related to the details of the treatment of produced water. That has not been where my main expertise is. What I'm offering up today his comments on the technologies that are available to treat all types of industrial and municipal wastewater, and the abilities to, and the fact that these technologies are currently developing and improving all the time. I mean, as for desalination of seawater, 50 years ago, we couldn't do it with reverse osmosis. Now there's dozens of reverse osmosis seawater plants because the technologies developed, the costs have come down. I'm testifying the technologies are being developed and could likely exist in the future, and that banning or prohibiting the discharge of produced wastewater will stifle the development of these technologies and basically eliminate a potential water source in water short areas.
So despite having given comments to the EPA regarding produced water and being involved with the oil and gas industry for 50 years, providing regulatory comments and analysis, you don't stay up to date on the research concerning produced water. Is that right?
That's correct. I haven't spent any significant amount of time doing that.
Okay. And so you're not aware that Dr. Van Gosh has published over 180 peer-reviewed academic research papers, 34 of which were specifically on the topic of produced water?
No,
You're not aware that Dr. Van Gosh has received millions of dollars in grants to study produced water and industrial pollution?
well, you just told me so, but no, the answer was I had no reason to look for that because that is not what I was basically engaged to look at for this particular hearing.
You're not aware that Dr. Van Gosh's H-index score is higher than the average H-index score of Nobel Prize laureates?
Then, be perfectly honest with you, it's like I said, I'm not an academic, so I don't track that sort of thing, and I don't know how meaningful it is. There's lots of accolades that give to each other in the in academia, so I just don't know what the quality of his research is.
And so you wouldn't be able to say whether Dr. Van Gosh is one of the world's leading researchers on produced water.
Mr. Dodd, I think you've gone as far as you can on this topic with this witness. Please move on.
That's all my questions. Thank you.
All right, thank you. Ms. Fox, do you have questions of Dr. Tischler?
No, I don't.
All right, Mr. Knight.
Doesn't like you.
I don't need fix. Good afternoon,
Good afternoon.
Dr. Tischler. You've never worked as a regulator, is that correct?
That's correct.
Never been involved with implementing or enforcing federal or state water quality standards?
No,
And
my hesitation is because if anybody had, my service in the Army was actually acting like a regulator. That's what a sanitary engineer does in the Army.
thank you for that clarification. So would it be fair to say that you would not consider yourself qualified to make jurisdictional determinations regarding water of the United States, specifically within New Mexico?
That would be accurate.
And regarding some of your earlier testimony, I I think you testified about the use of reverse osmosis for treatment of produced water. Is that correct?
I might have mentioned that it was a technology that Mr. Nerdy said earlier, but I don't recall specifically saying that reverse osmosis. I mean, it's a process that can be used at one or more stages depending on the PDS concentration of produced water.
That's exactly where I was going. Would it be fair to say that reverse osmosis is capable of treating produced water with a TDS, total dissolved solids, of up to approximately 45 grams per liter? Are you familiar with that?
Yes, that would be an equivalent to upper end on certain types of seawater.
But you're aware that the total dissolved solid content of most produced water from the Permian is higher than that, aren't you?
Yes, I
And finally, any discharge of treated produced water west of the 98th parallel would still need to meet state water quality standards. Is that right?
yes.
Okay, that's all the questions I have.
All right, thank you, Mr. Knight. Any redirect?
I have no
Mr.
redirect.
All right. Any reason not to excuse Dr. Tischler at this point?
Not that I'm aware of.
Thank you very much, Dr. Tischler.
Thank you. Thank you, Madam Examiner and Commissioners.
We would offer Exhibit 13. I understand your conditional ruling on the corrected version, but we offer that. Exhibit 15 is CV.
Exhibit 15 is a CV. All right. I'll pause for a moment in the event there are any objections to Exhibit 15. Hearing none. Thank you. It's admitted. Righty. Where are we going next?
Yeah, unfortunately, and we did not expect Mr. Tischler to go that fast. So we don't have neither Mr. D'Antonio nor Mr. Balch were available. I was going to give my position statement.
That's terrific. So we have your position statement. We also have a position statement from Mr. Cox,
Okay.
who wasn't invited to give his yet. So why don't we start with you, and then I'll move to Mr. Cox.
All right. Good afternoon, Mr. Chair, members of the commission, Madam Hearing Officer. I want to start by making clear that NMOGA supports the safe reuse of water, including produced water. As the governor has recognized, in a dry state such as ours, reuse of produced water offers unique opportunity to conserve freshwater resources and meet our needs going forward.
Mr. Wexler, you're reading, so slow down.
To make that happen, the commission must adopt a rule that protects human health and the environment, while at the same time encourages reuse and promotes New Mexico's continued leadership in the area of reuse of produced water. The version of the reuse rules that NMED filed in December of 2023 would accomplish those twin goals. Those are the rules that initiated this proceeding. Unfortunately, 3 months after proposing the reuse rules to the commission, NMED amended its proposed rule. The reasons for the proposed amendments are unclear, especially considering the department had no new information on which they relied. The primary change in the new amendments is to prohibit discharge permits for all produced water, including treated produced water. To put this in perspective, the commission has never before adopted a rule prohibiting discharge permits from an entire category or source of water. The commission should reject NMED's unprecedented prohibition and instead adopt the common sense solution embodied in the original proposal. And I say that for 4 reasons. First, the law does not support NMED's proposed prohibition on discharge permits for all treated produced water. Second, the state of science does not support NMED's proposed prohibition. Third, NMED's proposal to prohibit discharge permits for treated produced water is simply bad policy. And fourth, the existing procedures for discharge permits are protective of human health and the environment. Now, before I turn to those 4 reasons, I want to comment briefly on the case that the other side has presented to you. Unfortunately, much of what we have heard from the other side is based on hyperbole and exaggeration. For example, they say that there is no information about produced water. They argue that produced water cannot be treated for any purpose, but that's obviously not true. While there's room for reasonable debate on the state of science, such categorical statements are not helpful, and they don't meaningfully advance our collective goal of developing a substantive and protective rule. On the subject of science, NMOGA agrees that the rule adopted by this commission should be driven by science, which we think very clearly supports our position. Rather than tangible evidence of science, however, the other side's case rests on the dubious concept of unknown unknowns. As lawyers, scientists, and engineers, we base our decisions on provable facts, methods, and expertise. The vague concept of unknown unknowns does not lend itself to that critical evaluation. For example, when we've asked their witnesses what pollutants are present in all produced water in New Mexico, their answer is that it's unknown. And when we ask why the existing water quality standards are not protective of human health and the environment, unknown. When we ask what pollutants cannot be treated, also unknown, and the list goes on. But there are always things that we don't know. And in that sense, their position is really one of regulatory paralysis. For example, as I mentioned, I think yesterday, NMOGA supports the adoption of a reasonable standard for produced water. And when that standard is proposed, however, the same groups are going to be before you again, claiming you cannot adopt a standard because there are too many unknown unknowns. And following that logic is not good government, and it makes for bad regulations. The practical and prudent approach is to adopt regulations based on our best understanding, not the fear of unknown. So turning then to the 4 reasons the commission should reject the department's unprecedented proposal to prohibit discharge permits. First, the proposal doesn't find any support in the law. So I want to start with 7464P, as in Penelope, of the Water Quality Control Act. This is an express direction to the commission from the legislature, and it says that the commission, quote, shall adopt regulations to be administered by the Department of Environment for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water. That direction could not be clearer. It then goes on to give examples of the types of reuse contemplated by the legislature, including road construction, ice or dust control, construction, or land application unrelated to the oil and gas industry. But rather than follow that guidance, the department is proposing that you reject the legislature altogether and instead adopt a regulation that would prevent any discharge, recycling, or reuse of treated produced water. When I questioned them about the authority for their proposed prohibition, the sole provision upon which they rely is the first sentence of 7464E, as in echo of the Water Quality Control Act. Now that provision says that the commission, quote, shall adopt, promulgate, and publish regulations to prevent or abate water pollution in the state. For that provision to justify the proposed prohibition, the department must present evidence that all produced water is water pollution, and no produced water can be treated to a safe level. Now they've been unable to do that for 3 reasons. First, you've heard from witness after witness that produced water is variable and has different characteristics depending on the formation from which it originates, as well as several other factors. For example, the record shows that produced water from the Raton Basin is often cleaner than the surface water in that area, so therefore not pollution. Second, the department was simply unable and unwilling to make that representation to you. For example, Dr. Hu, the expert on who the department relied for this issue, testified as follows, and I quote from his transcript. Sorry, I cannot make a conclusion for the water pollutant for all produced water. So you ask for the water pollutant in all produced water. I cannot make a conclusion for all produced water. Third, and I'll mention more about this in a moment, but it's uncontested that produced water can be treated. And the Environment Department has admitted that they can be treated to satisfy existing water quality standards. And so the third regulatory hurdle for them is 7464D. And as I said, this commission has never before adopted a prohibition for a discharge permit based on a source or category of water. Instead, the Water Quality Control Act contemplates the adoption of standards that must be met before water can be discharged. Here, the department has offered no evidence for why the existing standards are insufficient. And even more problematic, the department seems to be contemplating an end run around the requirement around the statutory requirements, and the commission shouldn't allow that to happen. So turning to the second reason to reject the department's proposal to prohibit discharge permits, the facts don't support NMED's proposal, and I'll just focus on two of them. First, researchers, especially New Mexico-based researchers, have made some remarkable advancements in our understanding and characterization of produced water. Again, just as one example, you've heard about studies in the Permian Basin right here in New Mexico that show that there are approximately 100 constituents of produced water and approximately 20 to 30 unique constituents based on location and geography. That's a manageable number. And just yesterday, you heard Mr. McCurdy testify that we're on the cusp of closing the gap so that we fully understand produced water. We admit it, we're admittedly not there yet, which is to say we don't know everything about produced water, but that's neither uncommon nor an obstacle to safe treatment and discharge of produced water. For example, the department has conceded that there's also a large number of unknown constituents in municipal water, domestic wastewater, but we're quite capable of treating that effluent. The same is true for produced water. Which leads me to my next factual point, and that is that produced water can be treated. It can be subjected to pre-treatment, treatment, and post-treatment procedures that remove the contaminants and allows the treated produced water to meet applicable standards. You have heard no credible contrary evidence. Again, just as an illustration, on behalf of the Environment Department, Mr. Herman admitted in both his pretrial testimony and here today, or here a couple months ago in the hearing, that produced water can be treated to satisfy all existing water quality standards. That should end the inquiry. The third reason to reject NMED's proposed discharge permit prohibition is that it would create bad policy. And here I'll briefly focus on three reasons. Reuse, recycling, and conservation is obviously good policy. It's surprising to me that the Environment Department and the environmental NGOs are asking you to turn away from these principles. We're a very dry state that needs water. Treated produced water can be an important part of that solution. That's why the governor has proposed her strategic water plan and has made clear in the state's 50-year plan that produced water is a viable source on which New Mexico must rely. But that can only happen if you adopt reasonable rules and reject the proposed prohibition. Next, you've heard that the industry is prepared to invest significant dollars into New Mexico communities for demonstration projects and eventually permanent facilities. But companies have choices on where to invest their dollars. And if the commission adopts the Environment Department's proposal, it will discourage that investment here in New Mexico. The companies will go elsewhere. Third, New Mexico and its and the consortium here are widely considered to be leaders in the area of reuse of treated produced water. You've heard uncontested evidence that to advance the science, researchers and industry need the ability to obtain a discharge permit so they can do things like research projects involving agriculture and irrigation. If you adopt the proposed prohibition, it will inhibit ongoing research and it will relinquish New Mexico's leadership in this area to another state. And so now turning to the existing procedures, as I said, NMOGA supports the adoption of reasonable science-based standards for produced water. We're confident that technology exists to meet those standards. Unfortunately, NMED has chosen not to propose standards at this time. The question in this case, therefore, becomes, how do you handle treated produced water until new standards are adopted? And the answer is that your existing procedures for discharge permits are protective of human health and the environment. Now, again, while the other side has made their vague references to unknown unknowns, no party has expressed an evidence-based or science-based reason why existing water quality standards are not protective, at least until we adopt new standards for produced water. So let me talk briefly about the process for a discharge permit. The discharge permit process requires an applicant to fully characterize the source water to NMED's satisfaction. So if they're concerned that there's still unknowns, they can require the applicant to provide more information. It also requires the applicant to present a plan for how that water will be treated and how that water will be discharged. That will provide the department the opportunity to evaluate the plan, for example, for a pilot or demonstration project. If the department is unsatisfied, or if they need further information, it can require the applicant to provide that information. And no discharges are allowed until it can be proven to the department, to their satisfaction, that the discharges will meet all applicable requirements. And if the department has concerns, it can require additional conditions to ensure that the discharges are protective of human health and the environment. For added measure, there's sampling and monitoring requirements that ensure that if there is any problem, we identify it and we ensure that it's corrected. Now, yesterday, NEE raised the requirements in Texas for a letter of authorization for a pilot project. Provisions for a discharge permit are quite similar. In addition, the Commission has adopted the discharge permit procedure specifically to protect human health and the environment, and that process will work until we adopt these new standards. In the meantime, meaningful pilot and demonstration projects will be able to proceed in New Mexico. Allowing discharge permits for treated produced water also solves some of the ancillary problems that have been raised in this hearing. For example, there is already an approved procedure for ensuring notice and the opportunity for the public to participate. And while some parties have pointed to the requirement in the Produced Water Act that a permit is required to reuse produced water, allowing discharge permits would satisfy that provision. Now, the only reason, at least until today, and I'll talk about that here in a second, but until today, the only reason that we had heard from the department for bypassing this tried and true procedure was provided by Mr. Herman. And he said in his pre-filed direct testimony, I'm going to read this whole quote because I found it quite remarkable. Quote, due to the way the permitting regulations in 20.6.2 NMAC are written, there is a possibility that a person could submit a discharge permit application to the department that either does or does not identify treated water as the source, and the department would have to grapple with processing the application and either developing a draft discharge permit that is protective under the existing 20.6.2 NMAC permitting regulations, or deny the application, which would likely draw a challenge from the applicant. But overseeing that process, the process of, in his words, developing a draft discharge permit that is protective, that is the very job description of the department. It is not a reason to prohibit discharge permits or stifle research. And now today, we heard a different theory through Mr. Knight's cross-examination. He suggested that 7465D prohibits denial of discharge permits unless a standard is being violated. But I had a hard time understanding why that would help NMED's position, because that's just an argument that you must adopt a new standard, which of course they're not doing here. And ignores that, as Mr. Herman admitted, NMED can always add conditions to permits to make sure they're prohibitive. And the recognition by Mr. Herman that in fact, existing standards can be met. Which brings me to NMOGA's recommendation to the commission. And I hope I'm answering Commissioner Brankard's question from yesterday and clearing up any confusion. And that is, we have two alternative recommendations for the commission, and we would support either path. The first path is adopt NMOGA's version of the proposed reuse regulations. This is basically the rules that were developed over well over a year by the department with the help of all stakeholders those proposed by NMED with some additional cleaning up. That proposal is attached to Mr. D'Antonio's testimony. Or alternatively, the commission could either stay the current proceeding or deny the current proposal, but give clear instructions to the department and parties to propose standards for produced water and clean up some of the other deficiencies in the department's proposal. NMOGA would support either alternative, and we think it would essentially result in the same outcome. The develop of standards in the near future while encouraging the continued development of pilot and demonstration projects to further our understanding of treatment and reuse for produced water in a way that's protective of human health and the environment. Thank you.
Thank you, Mr. Wexler. Let's see, Mr. Cox.
Thank you, Madam Hearing Officer. Can you hear me?
We need you a little bit louder.
A little louder.
Yeah.
Is that better?
That is definitely better. Thank you.
Okay. Good morning, Chair, Commissioners. My name is Colin Cox with the Center for Biological Diversity. We're asking the Commission to deny this rulemaking petition because the proposed rule fails to protect our waters and our health. We ask the Commission to instead adopt a rule prohibiting discharge and reuse. The proposed rule will allow large-scale industrial projects to use toxic oil and gas waste outside of the oil field without any standards, safeguards, or limits. The rule also allows operators to experiment with toxic oil and gas waste in demonstration projects outside of the oil field on whatever terms the operators set for themselves. My first point is that fluid oil and gas waste is a big toxic problem. For every barrel of oil pulled from New Mexico's ground, we get roughly 4 barrels of toxic fluid oil and gas waste. The industry refers to this waste with the inaccurate and misleading term produced water, but it is not water, it is waste. And oil companies pulled over 86 billion gallons of this waste out of the ground in New Mexico in 2022. This waste is highly toxic. It can contain over 1,100 different pollutants, including carcinogens like benzene, toluene, and xylene, as well as radioactive particles, including uranium, radium, plutonium, polonium, and thorium. It can also contain toxic fracking chemicals that are kept confidential from the public. This toxic fluid waste is either disposed of or reused in the extraction process. There are thousands of storage and disposal ponds and pits across the state containing this waste. Many of these ponds and pits leak and contaminate the land and groundwater around them, as well as emit hazardous chemicals into the air. Oil and gas operators in New Mexico report more than 1,000 spills each year, totaling millions of gallons of fluid, and most of that is this waste that we're talking about. Oil and gas companies typically dispose of this toxic waste by injecting it deep underground into saltwater disposal wells. But this injection process is expensive. It poses risks to our waters, and it causes earthquakes. Because the oil industry is running out of cheap places to store this waste, they're looking for other ways to get rid of it, specifically reuse, which means selling it back to us and using it for drinking water, agriculture, livestock, and industry, among other uses. This rule is the first step in making the reuse of this toxic waste a reality in New Mexico. In 2019, New Mexico passed the Produced Water Act to begin the process of legalizing reuse of this toxic waste. The Oil Conservation Division of the Energy, Minerals, and Natural Resources Department was given control over how the waste would be reused in the oil field. And the Water Quality Control Commission of the New Mexico Environment Department was given control over how the waste would be reused outside of the oil field. This split jurisdiction between two agencies has resulted in confusion between MNERD and NMED over who has authority over a given project and just what it means to be on or off of the oil field. Further, a new group was created, the New Mexico Produced Water Research Consortium, to monitor research projects and conduct research into the treatment and reuse of this waste. The consortium is supposed to be supervised by NMED, but NMED has failed to exercise its control and instead allowed the consortium to bow to industry demands. Scientists from the consortium and from NMED admit that we do not know if this oil and gas waste can be reused safely. We do not know. They admit that more research is needed to figure out just how toxic this waste actually is. And they admit that more research is needed to figure out if it's even possible to clean this waste enough to reuse it safely. In other words, the reuse of fluid oil and gas waste is not ready for prime time. And that's why this rule should be a simple and complete prohibition on discharge and reuse. And to be clear, that's the center's position. That New Mexico needs a rule that prohibits discharge and prohibits reuse. Instead of that simple prohibition, the rule authorizes the reuse of toxic waste for large-scale industrial projects outside of the oil field. No safeguards, no limits. And the rule also allows oil and gas companies to experiment with the reuse of toxic fluid oil and gas in demonstration projects without safeguards or oversight, again, outside of the oil field. NMED is asking us to trust oil and gas companies with this stuff, both in experiments and in large-scale industrial settings. But the proposed rule is not based on science, and it lacks any science-based standards. It authorizes reuse of this toxic waste for industrial projects and demonstration projects, without any requirements beyond appropriate treatment. That's the only pseudo standard in this rule. The toxic oil and gas waste be treated to an appropriate level for whatever purpose it'll be put to. Whether that's for industry or for experiments with drinking water, watering crops, livestock, etc. But appropriate is a meaningless standard. There's nothing in the rule that says what appropriate treatment is for any of those uses. And NMED and the consortium's own statements reveal that they do not know what appropriate treatment actually means. They don't even know how to reliably detect and measure more than 1,000 of the 1,100 pollutants that can show up in this waste. The consortium and NMED both admit that more research is needed to determine if this waste can ever be used safely outside of the oil field. And they also admit that this treatment of the waste that the parties have been talking about has never been demonstrated at the scale that they want to authorize. Even the proponents of reuse and discharge at this hearing have admitted this. Mr. Hightower, director of the consortium, admitted that we aren't quite there yet. The science isn't quite there yet on reuse and discharge, but he urged the commission to take a chance on reuse. And yesterday, Mr. McCurdy, speaking on behalf of the New Mexico Oil and Gas Association, said the science was almost there. Almost. He urged the commission to open the door to reuse so that New Mexico will be ready if the science supports it in the future. Not quite there. Almost there. If future science supports it, take a chance. These statements cannot be the basis for rulemaking. Science simply does not support the reuse of toxic fluid oil and gas waste outside of the oil field, and this rule will not help us develop that science because it lacks oversight or accountability for the industry. While the Produced Water Act states that NMED must require a permit for any reuse of this toxic liquid waste, the proposed rule instead uses a notice of intent scheme to authorize these projects, with very few, if any, meaningful requirements. Under the notice of intent process, operators, and not NMED, decide how they want to manage their project, what contaminants they want to measure, how they want to manage transportation, how they want to clean up spills, whether they want to protect their workers from exposure to the dangerous chemicals that may be present in the waste. And while operators are required to share any data they collect with NMED, the rule leaves it entirely up to them what data to collect in the first place. The only condition on industrial projects is that they must limit public access. So as long as they put up a fence, or maybe just a post with a no trespassing sign, they can reuse this toxic waste without limit. The rule does not require operators to admit how toxic the liquid waste is. They're not required to disclose all the contaminants in the waste. They're not required to test for radioactivity, even though studies have shown that oil and gas waste can have radioactivity levels 40 times higher than EPA standards for clean drinking water. They're not required to test for PFAS. They're not required to test for anything in particular at all. And the rule doesn't require them to remove everything in the waste. Operators are not required to treat the fluid oil and gas waste to any specific level or remove any specific toxic chemicals before using it in industrial projects or experimenting with it in demonstration projects. In place of meaningful standards and oversight, the proposed rule allows operators to do whatever they want as long as it won't result in a discharge to surface or groundwater. They get to decide how to design the project and what to report. They get to make the project as large as they want. This lax enforcement regime has already proven inadequate to protect public health and the environment from the oil and gas industry. Look at our deteriorating air quality in the Permian Basin. Look at the number of spills they report on a daily basis, annual basis. The industry must not be given free rein to play with this hazardous toxic waste. Another glaring issue with the petition is the lack of any public notice or opportunity for public participation when NMED approves these reuse projects. NMED could authorize a large-scale industrial project basically next door, where toxic oil and gas waste would be trucked in and out every day, and there would be no chance for the public to comment on or challenge that project. The public wouldn't even be aware of it until it was already under construction. All the operator has to do, again, is put up that fence or that no trespassing sign. In conclusion, I want to talk about what we want, or what this rule fails to do and how to fix it. So the rule fails to meet the rulemaking requirements in New Mexico law. It does not rely on credible scientific data in 74-6-4D, or the best scientific information in 74-6-4K. In fact, it ignores the consortium's own conclusion that more research is needed before we know if this stuff can be reused safely. The rule also fails to meet the explicit requirements of the Produced Water Act, under which NMED must require a permit, not a notice of intent, but a permit for any reuse. That's in 70-13-4D. To resolve these deficiencies, the rule should be rewritten as a simple prohibition on reuse of toxic fluid oil and gas waste outside of the oil field. It's that simple, a prohibition on discharge and reuse. In conclusion, fluid oil and gas waste is toxic. It is carcinogenic. It is radioactive. NMED and the operators who make this stuff don't even know how to accurately assess just how toxic this waste is, or what it will take to adequately clean it up. Treatment has never been scientifically demonstrated at scale. Despite this reality, the proposed rule allows the reuse of toxic waste at industrial scale without limits, standards, or oversight on whatever terms the oil and gas companies set for themselves. Because of this, the rule fails to adequately protect our waters and our health and our environment. We ask the Commission to reject this proposal and instead adopt a rule prohibiting discharge and reuse. Thank you for the opportunity to talk to you today.
Thank you, Mr. Cox. I'm going to make the same request of you and Mr. Wexler. We'd like to assure that the transcript has the entirety of your comments. Would you be willing to mail the written form to Ms. Jones?
Be happy to do that, Madam Hearing Officer.
Thank you.
I'm also happy to do it. It may not capture all of my comments.
That's fine. Thanks. Thank you very much, both of you gentlemen. All right, so at this point, there's something else we can profitably do with our time, Mr. Dodd.
Madam Hearing Officer, Ms. Nasi unfortunately had to leave, but she has asked me to ensure that I move for the admission of New Energy Economy exhibits 19 through 33 with the exclusion of 21.
Correct. 19, 20, and 22 through 33.
Excellent.
Yeah. All right. Let me pause for a moment in the event there are objections.
So here's my objection. It's a conditional objection, and that is, as you know, there's a number of NMOGA exhibits that fall into two categories. The first category is the documents related to the consortium documents and presentations. The second is there's a handful of documents that were related to projects that were being done by companies. Those are subject to an objection motion to exclude on the basis of lack of foundation. We understand that the rules don't require the kind of foundation, that what they require is those to be identified and to be relevant. And if we are right about that, we have no objection. We understand why they're putting in these documents. However, my objection is conditional on, when we offer those exhibits, if they are excluded on the basis of foundation, the same rule should apply to the NE exhibits.
Thank you very much, Mr. Wexler.
Your Honor, can you hear me?
Oh, yes, Mr. Maxwell.
Yes, I'm on my phone. I'd like to add, I acknowledge that the foundation for these exhibits may have been adequately established during the cross-examination of expert witnesses to ensure a comprehensive record of the facts and to prevent unnecessary delays. I believe it would be fair and equitable to admit these exhibits into evidence at this time. Therefore, I am withdrawing my previous objection enjoined with NMOGA and Select Water Solution and expressing my wish that these exhibits now be admitted. Thank you.
Thank you. Ms. Fox?
Thank you, Madam Hearing Officer. Just briefly, I wanted to note that our objection is not based on foundation. It is based on relevancy to the NMOGA exhibits, and of course, the hearing officer's direction that the motion to exclude be decided after the close of evidence was a good one. And so I've been listening to the evidence in the case, and there will be exhibits that NMOGA has introduced that we move to exclude, for which we will withdraw the objection. I mean, specifically all the McCurdy exhibits 75 to 127, for example, will be withdrawing. So haven't made a determination on all of them, but did want to clarify that the objection is based on relevancy, and B, we will be withdrawing some of our objections, or I'm not sure how many in light of the evidence presented.
Thank you very much for that, Ms. Fox.
Madam Hearing Officer,
Commissioner Brinker.
I was just struggling to figure out where these new energy economy exhibits are.
They're probably in the Dropbox, Mr. Dodd.
My understanding is that they're in the Dropbox.
They're in the Dropbox.
Okay, well, I can't access the Dropbox here. So
Or you can't?
no, and so I will have to do it.
There's some technical issue. I think it's the firewall here creates issues with accessing the Dropbox.
Okay.
But I believe that it's accessible. Some parties have been able to access it here.
So I've been able to access it on my phone, although it's not easy to read. I didn't realize anyone else was having issues. I'm sorry.
Yeah, I think it's a firewall issue here at the White House.
All right. The magical phone. Okay. All right. Exhibits 19, 20, and 22 through 33 are admitted. And I think what I've detected, among the commissioners, I'm just speaking generally, is a strong appetite to read the papers that have been submitted, and to have some understanding of the state of research in this area. And I certainly understood from Mr. McCurdy's testimony. I thought he drew a good distinction between saying we're there and it's not as though no work has been done, right? I mean, I thought he drew a really good distinction there. All right, so those are admitted. We can talk again about the NMOGA exhibits when they are finished offering them. Thank you for that, Ms. Fox. Mr. Dodd.
Just to make it absolutely clear for the record, you said exhibits 19, 20, and then 23 through 33 are admitted. That's new energy economy 19, 20.
Yes, and of course with a dozen parties, although there's letters and numbers available, I don't know any other languages. So.
Absolutely. No, I just wanted to make it clear for the record that it's new energy economy.
NEE. Yeah, thank you.
very much.
Anything else we can do while we're together before I just mention two things for Tuesday? We'll have public comment again at 9 and 1. we really do have to be strict about not having people offer oral comment if they've already offered it this week or in May. Everyone should sign up with Pam. We'll continue to have obviously a court reporter and a Spanish language interpretation team, and there will be a new link. So if you captured that link for this week and used it over and over again, please understand you have to go back to the calendar and there will be a new link. So we are not meeting on Monday. Pam will put something explicit about that fact, and we'll resume again Tuesday at 9. Thank you all.
A great weekend.